Bringing one more part of fundamental rights and fundamental duties in the series of our Constitution. The different purposes for which the writ of habeas corpus is available may accordingly be stated as follows. For the enforcement of fundamental rights, it has already been explained that under our Constitution, the right of personal liberty is guaranteed against the state by Article 21, which says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Hence, if the executive has arrested and detained any person without the authority of any law or in contravention of the procedure established by the law which authorizes the detention or the law which authorizes the imprisonment is itself invalid or unconstitutional, the High Court or the Supreme Court may issue a writ of habeas corpus against the authority which has kept the person in custody and the order the release of the person under detention. It will also issue where the order of imprisonment or detention is ultra vires the statute which authorizes the imprisonment or detention. The writ of habeas corpus is however not issued in the following cases: where the person against whom the writ is issued on the person who is detained is not within the jurisdiction of the court; to secure the release of a person who has been imprisoned by a court of law or on a criminal charge; to interfere with a proceeding for contempt by a court of record or by parliament. Now, mandamus literally means a command. It demands some activity on the part of the body or person to whom it is addressed. In short, it commands the person to whom it is addressed to perform some public or quasi-public legal duty which he has refused to perform and the performance of which cannot be enforced by any other adequate legal remedy. It is therefore clear that mandamus will not issue unless the applicant has a legal right to the performance of the legal duty of a public nature and the party against whom the writ is sought is bound to perform that duty. It is discretionary remedy and the High Court may refuse to grant mandamus where there is an alternative remedy for redress of the injury complained of. In the matter of enforcement of fundamental rights, however, the question of alternative remedy does not weigh so much with the court, since it is the duty of the Supreme Court or the High Court to enforce the fundamental rights. In India, mandamus will lie not only against officers and other persons who are bound to do a public duty, but also against the government itself, for Article 226 and 361 provided that appropriate proceedings may be brought against the government concerned. The writ is also available against inferior courts or other judicial bodies which they have refused to exercise their jurisdiction and thus to perform their duty. The purpose for which a writ may be issued may now be analyzed as follows. For the enforcement of fundamental rights, whenever a public or officer or a government has done some act which violates the fundamental rights of a person, the court would issue a writ of mandamus restraining the public officer or the government from enforcing that order or doing that act against the person whose fundamental rights has been infringed. Thus, where the petitioner who was otherwise eligible for appointment to the subordinate civil judicial service was not selected owing to the operation of a communal rotation order which infringed the fundamental rights guaranteed to the petitioner by Article 16(1), the court issued an order directing the state of Madras to consider and dispose of the petitioner's application for the post after taking it on the file on its merit and without applying the rule of communal rotation. Apart from enforcement of fundamental rights, mandamus is available from a high court for various other purposes, as for example, to enforce the performance of a statutory body where a public officer has not a power conferred by the constitution or the statute. The court may issue a mandamus directing him to exercise the power in case he refuses to do it. The writ will also lie to compel any person to perform his public duty where the duty is imposed by the constitution or a statute or a statutory instrument. To compel a court or judicial tribunal to exercise its jurisdiction when it has refused to exercise it. To direct a public official or a government not to enforce a law which is unconstitutional. Mandamus will not be granted against the following persons: the president or the governor of a state for the exercise and performance of the power and duties of his office, for any act done or purporting to be done by him in exercise and performance of those powers and duties. Mandamus does not lie against a private individual or a body, whether incorporated or not, except where the state is in collusion with such private party in matter of contravention of any provision of constitution or statute or a statutory instrument. The writ of prohibition is a writ issued by the Supreme Court or a High Court to an inferior court, forbidding the latter to continue proceeding therein in excess of its jurisdiction or to usurp a jurisdiction with which it is not legally vested. In other words, the object of the writ is to compel inferior courts to keep themselves within the limit of their jurisdiction. The writ of prohibition differs from the writ of mandamus in that while mandamus commands activity, prohibition commands inactivity. Further, while mandamus is available not only against judicial authorities but also against administrative authorities, prohibition as well as certiorari are issued only against judicial or quasi-judicial authorities. Hence, prohibition is not available against a public officer who is not vested with judicial functions where excess of jurisdiction is apparent on the face of the proceeding. A writ of prohibition is not a matter of discretion but may be had of right. In India, a writ of prohibition may be issued not only in cases of absence or excess of jurisdiction but also in cases where the court or tribunal assumes jurisdiction under a law which itself contravenes some fundamental right guaranteed by the Constitution. The Supreme Court can issue the writ only where a fundamental right is affected by reason of the jurisdictional defect in the proceedings. Though the prohibition and certiorari are both issued against courts or tribunals exercising judicial or quasi-judicial powers, certiorari is issued to quash the order or decision of the tribunal, while prohibition is issued to prohibit the tribunal from making the ultra vires order or decision. It follows, therefore, that while prohibition is available during the pendency of the proceeding and before the order is made, certiorari can be issued only after the order has been made. This is all about today's part of fundamental rights and fundamental duties in the series of our Constitution. Thanks and regards.